when we make modifications to the criminal justice system, they happen to prosecutors, not with or in consultation. And so that's how you know I used to represent them. And my old friends are probably smiling. But I think one of the great benefits of this is that you actually get to decide the inflow. So when you talk about, this doesn't exist at the federal level, but there is legislation very similar. What our conversations have been like with U.S. attorneys is very similar, as well as recently with the Department of Justice, is the idea that prosecutors would control the intake, but also have a better view of their own system based on whether they choose to accept petitions or whether they solicit them from prior cases they've reviewed. Makes a big difference. And the reason that I say it makes a big difference is it allows you to fit within the structure of how many attorneys you have on staff or what you're looking at when it comes to funding or separate resources. Now, in some cases, as Hillary mentioned, they're folded into existing conviction integrity units. I talk a little bit about there's an office in San Diego. Yes, it's California, so we can all roll our eyes a little bit. But we love our friends in San Diego. And they have been able to fold it into existing conviction integrity units that then review cases that either in one of two things have happened. Either they themselves have already been reviewing those cases, looking into it, or they've received a petition through another mechanism under state law, but have decided this is the appropriate path because it's more holistic. It includes the victim input. It includes the additional opinions of DOC. I'd also say, I think we haven't touched on this, it also includes input from law enforcement involved in the initial case. I don't want to lose track of the fact that whether it's an investigating officer or sheriff's department, they have a role in this process. And as we've just explored this at the federal level, we would also expand that out to our federal law enforcement partners. So again, what uniquely, and it's not to compare to any other modifications in the justice system, but I think what makes this one uniquely interesting and uniquely supported by law enforcement is that it's comprehensive and including everybody in the process fairly. And I think we've missed that in some other cases. Here, we have the opportunity to actually solicit input, create a full picture. And I actually think the last benefit I've talked about a little bit in the past is there's also a benefit to that in returning individual, because now they know that the victim was involved in the process, the prosecutor, law enforcement, in different capacities, they now have a responsibility to all of those individual parties for success, and I think that puts more skin in the game across the board. So I just wish, if in an ideal world, we get to do individualized reviews of every single case, have the full facts in front of us and all of the parties at the table. This is one of the rare times we can actually accomplish that.
Okay. I think this could be another moment maybe for Marilyn, if you want to speak up a little bit about in your work previously at the Department of Corrections and currently at Right on Crime in Oklahoma, and just any ideas on how this might be useful from your perspective.
Yes, and I think when we were talking about what I was going to contribute today during this interim study, there's a lot of very, very smart people up here, and I know that my knowledge about this issue is not better than theirs, but I do have a lot of knowledge about Oklahoma-specific issues, working on criminal justice issues for about 12 years now in our state. And I will say one of the things I always caution lawmakers is we should not legislate based on one or two extreme stories or circumstances. I see it all the time. When you get a story that's in the news, it gets a lot of attention. Also, we want to change the law to go with that story. But I do have a few examples I want to use purely for the fact that sometimes we hear, well, this is not needed in Oklahoma. We don't have instances. We have other ways that we can address it. And some of the stories that are the instances I saw when I was working at Department of Corrections that stuck out with me, we had a young boy that was sentenced to DOC custody for about 30, 40 years, can't remember exactly, and in his judgment and sentencing paperwork, the judge said, we do not have mental health facilities or treatment for him in our district, therefore I'm sending him to DOC custody to get treatment. It was very obvious when you walked on the unit that this person, you did not have to be a medical person to know that this individual needed mental health treatment, and DOC was not the most therapeutic environment for them. But our hands were tied. We couldn't just, say, hey, state, we want to transfer them to Bonita. That's better for them because of the way he was sentenced. We had to take him. And I don't think justice or public safety was served in that instance. One of my jobs was I would get the calls from the lawmakers all the time because they'd get a mama call, or someone would contact them and say, hey, we've got this issue and I shouldn't be in custody and this happened to me and that happened to me. And my job was to really go and to look at their paperwork and to do some digging and talk to sometimes the DAs and figure out what the true story is. I will tell you 9 times out of 10, the story was not what they are presenting and the person did deserve to be in DOC custody. Every once in a while there was one, and one that stuck with me. It was an individual, and she contacted her state senator and said, I'm past the point of being able to ask for a modification. I've extended everything, but here's what happened to me, and I don't think it's fair. We should change it for future people. When I looked into it, I called this senator and I said, okay, usually I just send an email back, but I'm like, are you sitting down? Let me tell you the full story. She was in Oklahoma from out of state. She was riding in a car with her boyfriend, and they were pulled over. Her boyfriend had a significant amount of drugs in the car, enough for distribution. And they were both arrested and charged. He got 6 months in prison, and she got 15 years on an 85% crime. So the senator said, well, what was the difference? And I said, well, the only thing I can tell is she had a public defender, and she says she took a blind plea because she wanted to get home to her 8-year-old son. He had a private attorney who drug it out, and he was a veteran, so he was offered veterans court. No benefit to public safety in that instance. Unfortunately, that senator, she went and she called the DA, called several other people, said, can we do anything with this girl? There was nothing we could do. They said, no, under statute, there's nothing we can do to help get her released. Thankfully, as of today, she has served her 85%. She is thriving, so she is, and thankfully, a success story after that. We saw all sorts of things. The former attorney from DOC, he and I still kind of keep in touch, and we talk about some of these issues. We had 90 years in prison for second-degree burglary and possession of a stolen vehicle, 60 years for possession with intent to distribute, 28 years, and a suspended life sentence for drug possession, possession of stolen property, and false impersonation. One of the famous cases was an individual. She stole 2 purses from Dillard's and was given a life sentence. Granted, she had prior history of theft. The judge said, you keep coming back here and you're not learning your lesson. He didn't offer her treatment. He didn't offer any kind of alternative sentencing. Just said, you're not learning your lesson, life in prison. Thankfully, with her, we were able to get the governor to intervene and let her out. But I do want to kind of focus, like when you talk about kind of what's the issue? What's the issue, or what's the problem we're trying to fix? Are we a solution looking for a problem, or are there really problems out there? And there's a lot of those examples. But I really want to kind of pick on the 85% crimes for a second. I'm really glad the DA brought this up, because one of the things we saw a lot too when I was at DOC, and I'm going to give you guys a little bit of a history lesson, but I promise I'm going to tie it in. But back in the 90s, before Chairman Harris and I were even old enough to drive, the state, I know, you too. The state started, what they were doing all across the country of truth in sentencing laws. And that was them coming in and saying, everyone's going to get, minimum this sentence for these sorts of crimes. But there was never really any funding or real implementation of those laws that were put into effect. But we did start to see a strong uptick in the number of people being sent to DOC custody, but there was not an appetite at the state level to increase funding to DOC to handle all of these inmates. So what they did allow DOC to do is to start giving out credits. Now, those credits grew and became more and more. And you hear about how we used to give credits for donating blood. Give credits if you had your birth certificate, things that they don't do now. But they had to start doing those in order to ease that burden that they had on our prisons. So the state came in early 2000s, and I will say, so before pre-85% crimes, and you heard the DA talk about it, if a DA said, hey, I want someone to get 10 years in prison, I'm going to give them 22 years. And I know with the average and with how the credits that DOC is giving, time served, all that, then he'll serve about 10 years if I give him 22 years. But it built this frustration between the DAs and DOC, and there was always this fighting of like, well, I wanted him to serve this. Why'd you let him out? Well, he got credits, and we're allowed to do that under statute. And so the DA started kind of rationing up the sentence lengths that they were giving. And so we passed 85% crimes and said, okay, DAs, we'll come in, and here's a list. They were called, I think, like the 7 deadly sins originally. And we said, the worst of the worst. We're going to come in and we're going to say, whatever you give them, we're going to guarantee they will serve 85% of their sentence. Well, great. That sounds perfect. So when you want someone to serve 12 years or 10 years, you give them 12 years, meaning that at minimum they're going to serve 10. Unfortunately, that list kept growing every year, and it still grows every year. But what we started to see, and I saw this more times than I can count, was you would have a crime that was a non-85%. And so the DA is like, okay, I'm going to give them 10 or 12, so I know they served 10. Well, then it becomes an 85% crime. So you no longer need to ratchet up that. I'm going to go back. I'm sorry, I was spelling this wrong. It's numbers. I don't do well with numbers. I'm going to give them 22, so I know they served 10. But now it's an 85% crime, so you don't need to give them 22. You just need to give them 12. But we kept seeing judges still giving them 22 years, meaning that they were serving about 18 years instead of 10. So I remember asking several times and asking specific DAs or judges, like, why do you guys keep giving this? Well, here's the situation we were putting them in. January, I have a guy that commits a certain crime, and it is a non-85% crime, and I give him 22 years. November, I send it somewhere for the same crime, and it is an 85% crime. If I don't give them 22, my constituents are going to ask me why and think I'm being soft on crime. So I have to keep giving 22 for this sentence, for this crime, or it's going to look like I'm being soft on crime. And we saw that over and over and over again. So we are still seeing people that are in DOC custody today that have become a victim to that. And I think, this is me tying it all in, I think that this is a sort of a relief valve that can help these prosecutors to go back in and say, okay, we really only wanted this guy to get 12. He's now looking at 18. Let's modify, bring it back down so he gets the 12 that we wanted him to get. So.
Thank you for your presentation. You mentioned somebody 90 years for burglary.
Yes.
Do you know how many previous convictions that individual had?
I do not know. It was out of Creek County. I can dig up the name and the specific person, but yeah.
Yeah, that would be interesting. Same question on the one with 60 years. Do we know how many previous convictions they had?
Yeah, I don't have in the notes I have in front of me on their previous convictions. But, we can assume that some of these are because of enhancements, which we can argue. Sometimes I feel like they're appropriate. Sometimes I feel like they're kind of abused. Kind of the measuring tool we always use at Right on Crime is, does it serve a benefit to public safety in giving them that length of sentence?
Thank you.
Okay, let's